with us. We'll be beginning shortly. Before that, I'd like to invite Mr. Siddharth Gupta to give us an introduction of the esteemed speaker today. So,
good morning, everybody. We all know ably that Honorable Mr. Justice Dipak Misra has served as the Chief Justice of India from July 2017 to October 2018. In fact, introduction about his education, where he practiced is all provided on the internet. So, apart from that, except informing all of you, except telling all of you that he served as a puny judge with the High Court of Madhya Pradesh for around 14 years, from 1997 till 2010, whereafter he was appointed as a Chief Justice of Patna High Court, to be followed by his appointment as the Chief Justice of Delhi High Court. I would like to introduce Honorable Justice Misra with some lesser known facts, information which is not easily available in the public domain, and that is some of the landmark judgments delivered and authored by Honorable Justice Misra, which have become permanent inscriptions on the Supreme Court walls for all the future generations to come and read upon. Honorable Justice Dipak Misra is credited with authoring some of those judgments which focused primarily on the distressed, suppressed, and neglected fractions of the society, like the transgenders, LGBT community, women, child, so on and so forth. In fact, I can see there are a lot of students from NLU Odisha today, and some of the faculty members also. I must like to tell you that the idea of bringing National Law University Odisha amongst the top premier 10 national law universities, previous to which it was there, but somewhere down below the line was conceived, to bring it among the top 10 premier law universities of the country was conceived during the reign and regime of Honorable Justice Dipak Misra himself. And the idea started taking shape. And what you all must be seeing in your campus, the initial years, the first year, second year, third year, is what was conceived 4 or 5 years back when Honorable Justice Dipak Misra came to the Honorable Supreme Court. I must like to go on. Some of the noteworthy and historic judgments which Honorable Justice Dipak Misra has been author of must be thrown light upon. The Supreme Court of India in 2017 sent the prime accused in the Bombay blast case, Yaqub Memon, to the gallows. That copious judgment was authored by none else. The bold view was taken by Honorable Justice Dipak Misra himself. Colloquially, other one is colloquially known as the Nirbhaya rape murder case, is also in the credits of Honorable Justice Dipak Misra, where he took another bold view of sentencing harshest punishment of death penalty on the 4 prime accused persons who had committed the heinous offense of rape upon a young lady in Delhi. Honorable Justice Dipak Misra was also part of a path-breaking judgment in hundreds of matters arising from state of Uttar Pradesh, where the Honorable Supreme Court held for the first time that reservations in promotions is a constitutional anathema. The Honorable Supreme Court held that state cannot be permitted to provide reservations in promotions till and until it comes up with sufficient cogent data, field statistics, and survey report to show that reservation is necessitated in promotion, and that without it, the representation of the SC/ST community cannot be ensured within the constitutional fabric. Honorable Justice Dipak Misra also wrote a judgment spanning over more than 250 pages, which declined to declare the offense of criminal defamation section 299 IPC as unconstitutional, holding that one's right to personal dignity and to possess and continue it always trumps over others, third parties' right to criticize and use his fundamental right to speech and expression in an unrestricted manner. I would like to quote some beautiful lines and observations from some of the landmark judgments, in fact, which every law student or a fresh graduate of this field or discipline would like to read. Some of those few observations I would like to read, starting from the matter of Charu Khurana versus Union of India, which is a landmark judgment holding that stand-up makeup female artists in film industry could not be discriminated qua their male counterparts. Honorable Justice Dipak Misra on the question of women inclusivity observed thus, and I must read it, as it appears, though there has been formal removal of institutionalized discrimination, yet the mindset and the attitude ingrained in the subconscious have not been erased. Women still face all kinds of discrimination and prejudice. The days of yore, when women were treated as fragile, feeble, dependent, and subordinate to men, should have been a matter of history, but it has not been so, as it seems. In the celebrated matter of Navtej Singh Johar of India, which decriminalized the offense of homosexuality and gave a sense of liberation to the LGBT community of the country, Justice Dipak, Honorable Justice Misra observed bigoted and homophobic attitudes dehumanize the transgenders by denying them their dignity, personhood, and above all, their basic human rights. It is important to realize that identity and sexual orientation cannot be silenced by oppression. Transgenders have to progress from the narrow clauses. This is another quote from the judgment relating to transgenders. Transgenders have to progress from the narrow claustrophobic spaces of mere survival, hiding in there within their isolation and fears, to enjoying the richness of living. Another judgment, Joseph Shine versus Union of India, the Supreme Court decriminalized the offense of adultery qua women. Honorable Justice Dipak Misra inscripted his views in the following beautiful words: a woman cannot be asked to think as a man, and or as to how the society desires. Such a thought is abominable, for it slaughters her core identity. And it is time to say that a husband is not the master and women is not the property. Equality is the governing parameter. All historical perception should evaporate and their obituaries be written. Today, we are really fortunate to have got Justice Dipak Misra with us on the topic what we have requested all of you to attend, that is concept of constitutional identity by the Supreme Court. Constitutional identity, though that shall be explained by Honorable Justice Dipak Misra at length, I would, in my words, like to explain all of us have unique features. Our capacity to discern, our capacity to respond, our character, our integrity, our response to the pain and sufferings which people around us keep facing on a day-to-day basis. That is what shapes our identity, which makes us stand out from others around us, stand out from our peers. That is what something is all about constitutional identity. Constitutional identity, when we say, is an identity which in its core is perpetual and perennial, which never changes with the passage of time, but at the same time, the crust or the ephemeral or the periphery of which keeps changing on the basis of demands and expectations of the organic society and is a quintessential requirement of an organic constitution. With this brief introductory note, I would like to request Honorable Justice Misra to take over the mic and start addressing the audience.
Thank you. At the very beginning, I must say, I'm absolutely delighted that the CAN Foundation has devoted itself to hold this kind of webinars for the students at this difficult time. It's absolutely imperative that the students who are unable to attend classes keep themselves engaged in such a manner. Having said that, now let me proceed to deal with the topic as I understand. As far as I am concerned, constitutional identity is the Ellen Whittle, the life source of the Constitution. Sometimes people pose questions whether the Constitution of India has a distinct, discernible, or a decipherable identity. Needless to emphasize that our organic, flexible, and the compassionate Constitution has an unshatterable and unbreakable identity. There are some others who also posed a question whether the Constitution of India has a distinguished identity, a singular identity, or there are multi-layer identities in the Constitution. Two things emerge: identity of the Constitution and identity under the Constitution. First, I will deal with the first facet, then I will go to the second aspect. As far as the first one is concerned, one has to understand the idealistic structure of our Constitution. You see, one is the personality of the Constitution, and the other is the realistic actualization of the rights. I repeat this phrase: realistic actualization of the rights. To explicate, the first one supports the inherent and integral personality of a constitution. There, everyone has used the concept of personification, giving life to the constitution. The second one, the recognition of identities conferred under the Constitution. These identities are conferred with the passage of time by expansive interpretation. Now, having said that, now let me first focus on the first part. As there is a beautiful saying, you must address the first first. And a lawyer is expected to speak about best point first. So let's focus on the first. The theory of constitutional identity emerges with vibrance and vigor whenever there is fundamental and political or legal conflict. You see, when there is a conflict, when there is a discussion, when there is a problem, solution has to come. That has been the fulcrum of civilization. And if you go to the myths, and I'm digressing for a second, Amrita Manthan is conceptually is such an idea. This discovery of constitutional identity as a conception is to say the basic character, the spine, the structure of the Constitution. I like to borrow some idea from the medical science. This structure acts like an antidote in the event the power to amend the Constitution conferred on the Parliament under Article 368 of the Constitution acquires a character of an autoimmune disease, wherein the human system mistakenly attacks the body itself. To put it differently, when the power to amend the Constitution becomes destructive of the Constitution itself, the constitutional courts have a sacrosanct duty to use the inoculation to save the constitutional identity. That is their primary duty. It's because their duty is to save the sovereignty of the Constitution and to see that the Constitution is not used to destroy the Constitution itself. The supremacy of the Constitution is real supreme. It doesn't permit any other idea. I'm not going to debate on that. That is the final verdict of the apex court. The question with regard to the amendment and the change of the Constitution was the central issue or issues in Keshavananda Bharti. I'm aware all of you have read, but the beauty of wisdom is to read what you have already read. You always get a new perspective, new understanding, new in-depth, and that's life. Even if you read Aristotle today, you'll find sometimes he's so relevant in modern times. You can't ostracize him as an intellectual, and that's your objective proclivity as an intelligent man who understands a correlative in the proper sense. In Keshavananda Bharti, the court decided that Parliament could not amend the Constitution in such a way so that it can destroy the identity of the Constitution. Let's see how the judges spoke and what kind of language they used. All of us know language is a vehicle of expression. The intensity of expression comes with language. Justice Hegde and Justice Mukherjee spoke. One cannot legally use the Constitution to destroy itself. The personality of the Constitution must remain unchanged. I unquote. Justice Salat and Justice Grover, they were of the view, I quote, the Constitution has an identity of its own. An amendment made under a power, however widely worded, cannot be such as would denude the Constitution of its identity, unquote. Now mark the words here. The width of the power of amendment, and the second, denuding the identity of the Constitution. Thus, these two honorable judges are treating the Constitution as a living document, an organic being, and the other judges use the metaphor of personality by borrowing the idea from the world of literature, the concept of personification. Justice H.R. Khanna, in his own style, sanguinely simplistic in a way, says the word amendment postulated that the Constitution must survive without loss of its identity, which meant that the basic structure or framework of the Constitution must survive any amendment of the Constitution, unquote. Here the emphasis is on survival, resilience, that you can't destroy me. I am resilient. I meet the Darwinian theory, survival of the fittest, and my identity is my human system, and that doesn't betray me, though you are the caretaker. I'll come to that concept. Chief Justice S.M. Sikri observed, and I quote, the expression amendment of this Constitution doesn't enable Parliament to abrogate, to completely change the fundamental features of the Constitution so as to destroy the identity. Justice Sikri uses the word change. You change. In fact, the later judgment discuss about that change, and I'll be highlighting on that. Here, Justice Sikri said change, but such change, such amendment shall not destroy the fundamental feature. This fundamental feature will have some connection with the context and the context theory. Now we come to Minerva Mills case. In Minerva Mills, I'm quite impressed as a student of law by the language used. They're in a way throwing an invitation. It's slightly dramatic. Expression. I read this paragraph. It's a majority decision. Amend as you may, when the solemn document which the founding fathers have committed to your care, for you know the best the needs of your generation, but the Constitution is a precious heritage. Therefore, you cannot destroy its identity. Paraphrase here. What does the court say? What does the majority view mean? You know the best, the needs of the generation. And the Constitution or the founding fathers have handed over this Constitution to your care, committed to your care. But remember, you cannot destroy its identity. And while striking down, I must read this passage. The court said, any amendment of the Constitution which seeks to enlarge the amending power of the Parliament by freeing it from the limitations of unamendability of the basic structure would be violative of the basic structure and hence outside the amendatory power of the Parliament. Unquote. Look at the powerful language the court uses while striking down the amendment. That is why I have always emphasized on constitutional duty and the sanctity behind this duty. As you have seen, in 70s and 80s, when there was dilemma, there was conflict, and there are a lot of things as the history projects, the court used the basic structure doctrine to achieve the result, to save the fundamental features of the Constitution. And gradually, with the passage of time, the constitutional jurisprudence grew. The doctrine of checks and balances, you see, do not travel politically to the theory of checks and balances in that context. Here means the checks and balances of the amending powers. The Parliament could not have unhesitatingly proceeded to amend the Constitution. They have the duty to take care of the generation living in present time. They know what the needs are, but they have to keep in mind the fundamental features, the basic features, the basic structure of the Constitution. All of you, I assume, must have read Niagara's judgment. Niagara's upheld the constitutional amendment, but added there has to be promotion in reservation if adequate quota is presented. That's basic. The argument was that such an amendment was going against the fundamental right, and that fundamental right is destroyed, and that is why the basic structure doctrine is violated. The court here answers the issue in a different way. I'm reading only few lines to convey my thoughts, which I was in agreement in 2012 as well as in 2018, sitting in the Constitution bench. In Nagras, the court says, and I quote, "The main object behind the theory of the constitutional identity is continuity, and within that continuity of identity, changes are admissible depending upon the situation and circumstances of the day." Unquote. This is a nuanced study. The Constitution bench speaks about the identity in continuity, allows the change, but depending upon the situation. The situation must further the spirit, the purpose, the need of the Constitution. And that's what the court realized and saved the amendment with a part of it reading down in a different way or adding a qualifier. You see, when you talk about the basic structure, various concepts have been included in that basic structure. In Kuldeep Nair, the court said that parliamentary democracy and a multi-party system not in that judgment, in many other judgments, it came to be included separation of power, judicial independence, some of the fundamental rights, Article 14, 15, 19, 21, exclusively. A right to equality, constitutional governance, so many concepts came in. Interestingly, when I travel to my second point, I will illustrate how two other concepts have also been brought in within the concept of identity of the Constitution. Now, let's travel to Coelho judgment. You see, as you know, 9th schedule was protecting certain laws. They were not amenable to be challenged in the constitutional courts. In Coelho, the larger bench read and understood that this 9th schedule is really affecting the basic structure doctrine. It can't be in such a compartment. Now, as I'm speaking to students, please allow me to read two passages from that judgment. It's a very long judgment, and they have to understand the essence of this judgment. The doctrine of basic structure is propounded to shape the basic features. Article 21 is the heart of the Constitution. It confers right to life as well as right to choose. When the triangle of Article 21 read with Articles 14 and 19 is sought to be eliminated, not only the essence of right test, but also the rights test has to apply. Particularly when Keshavananda Bharti and Indira Gandhi cases have expanded the scope of basic structure over to cover even some of the fundamental rights, unquote. Then the court explains the synoptic view of the rights in part 3. And it says that the articles 14, 19, 15, and 21 constitute the core values to be followed, and they cannot be allowed to be abrogated, so that they can bring in such change to completely violate the basic feature of the Constitution. Please try to understand. The court is categorical about the rights test and is making a distinction between the right test and the rights test. Then the court says, and this part I will read, the doctrine of basic structure as a principle has now become an action. It is premised on the basis that invasion of certain freedoms needs to be justified. It is the invasion which attracts the basic structure doctrine. The existence of the power of Parliament to amend the Constitution at will with requisite voting strength so as to make any kind of laws that excludes Part 3, including power of judicial review under Article 32, is incompatible with the basic structure doctrine, unquote. You got the powerful passage. And here, the court is bringing the freedom. And also, eventually, in this case, the court issues various directions and comes to a number of conclusions. The first one is the laws made after 1973 can be challenged. Now, I'm referring to another judgment. That's Indian Medical Association case. In Nagras, the Constitution bench used the word content. Now let's see how Indian Medical Association treats it. I quote this passage. The prevention of destruction of the constitutional identity is the chief rationale in using the basic structure doctrine in instances of constitutional amendment, such as the one we are concerned with in the instant matter. Constitutional identity and continuance of such an identity are the primordial issues, and the identity ought not to be destroyed, unquote. Now we again find there is a reiteration of the continuity, the idea of continuance of that identity. Change, but don't destroy the continuity of the identity. And the change must be within the component of constitutional structure. You cannot put off or take away the filament of identity. That's the litmus test. In Ashok Kumar Thakur, dealing with principles of equality, the court uses the word modification. Please understand, they are not changing the basic idea. And I repeat, the basic idea is not changed. The fundamental concept is not changed. Let's look at this passage. The variability of changing conditions may necessitate the modifications in the structure and design of these rights. But the transient character of formal arrangements must reflect the larger purpose and principles that are the continuous and unalterable thread of constitutional identity. It is not the introduction of significant and far-reaching change that is objectionable. Rather, it is the content of this change insofar as it implicates the question of constitutional identity. The far-reaching, like promotion in reservation, then including reservation of seats in educational institution, they do fall within the constitutional identity because there is a continuity. There is it satisfies the context test as well as the context test. Now let's come to a jurist. What a jurist says about the constitutional identity. I have talked about some Supreme Court judgments. I'll refer to some. Now, Gary Jacobson says that there has to be experience, there has to be culture, all these are to be taken into consideration, but you can't destroy the identity. There could be transcendence of the past. He says the identity, I'm not quoting the part, I'm explaining in my language. Identity of the Constitution is located not only in the document's text, but in the everyday process of living within the framework of the document. Locating the identity of the Constitution requires us then to reference not only the text of the document, but also constitutional history and practice. The principle has to be simply and appropriately understood. It states about experience, transcendence of the past, resistance against its own destruction, and manifestation in different ways, in different settings. Now, what Jacobson says, he has referred to Edmund Burke. Burke has spoken differently because he was speaking in a different era. And he says, written and unwritten constitutions are both covered. That's the beauty of it. Be that as it may, as we understand the juristic understanding of the constitutional identity and the judge's understanding of the constitutional identity or the identity of the Constitution, there is no difficulty. Now, when I talk about the second aspect, identity under the Constitution, some say identity in the Constitution, like a citizen infers identity from the Constitution, or the Constitution recognizes the identity of the citizen. There is no conformment. You must appreciate and understand the rights are natural and they are recognized by our organic and compassionate document. Recently, the court has invented or discovered, they were there, but rediscovered constitutional morality, transformative constitution, and the purpose. In Navtej Johar, in a concurring opinion, it has been stated that inclusiveness and pluralism convey the idea of Article 14, and both these are part and parcel of constitutional identity. Actually, what is meant, the broadened expansion of constitutional identity sometimes has to be divided to take the identity or the personality or the fundamental features of the Constitution and the identity which is the identity of a citizen, which is conferred by the interpretative process, by the courts which the Constitution has recognized in a different way. There is a jurist, Maclean. He has remarkably stated, I quote one line, he's talking about democracy. Democracy is not just a right to vote, it is the right to live in dignity, unquote. What is the purpose of living if the dignity is lost? And that is what the constitutional morality, that is what the transformative constitutionalism, and that is what the constitutional governance have emphasized upon. You see, there is a beautiful historical enumeration, description. One of the first presidents of the United States was busy in drafting the Constitution of the United States of America. He used the word subject, but then brushed it aside so that the word doesn't exist, nobody can see. And changed the word to citizen, because he still had that colonial mindset while drafting from the subconscious. Nobody knew what was the word used. Lady found out after taking permission from the Congress of the United States, that I will try to find out. And eventually she found out that the original word was subject. And he said that, and everybody was delighted. Our founding fathers struggled hard to dechain us, to release us, to free us from the concept of subject and to confer us the right of citizenship, not the adult franchise, but the dignity. And that is why there's a transforming and changing constitution. Now I lead my conclusive part, and I have talked about the second part. Before I close, I must go to the transgender case, that's NLSA case. NLSA invoked the social interest jurisdiction of the Supreme Court as permitted under the NLSA Act. They transgender, the Supreme Court said they search for self-identification, and therefore their gender has to be recognized, because according to the court, dignity and respect matter, and gender expression is a right to freedom of speech and expression under Article 19 of the Constitution. Now, this is a distinct identity under the Constitution or in the Constitution, depends upon which preposition you intend to choose. Now, in conclusion, I would like to say, from the discussion, I feel it's graphically clear that the concept of constitutional identity, which began as a safeguard born out of judicial creativity for protecting the Constitution from being destroyed by itself through constitutional amendments, has emerged as a substantial part of the affirmative rights conferred by the Constitution, and thus cannot be allowed to be abrogated. No power of amendment can be exercised to destroy the identity of the Constitution, and no provision can be brought to create a dent in the identity under the Constitution, the identity of the citizen. Our organic document recognizes the second identity, and the first one is in itself the vertebra of the backbone of the Constitution and will not tolerate any dent or crack. The second recognition, or the second facet, which I've said the recognition by the Constitution, is inherent in the sense and spirit of the Constitution. We must understand the sense and spirit of the Constitution. I must thank you, the Can Foundation, for having given this opportunity to me to have talked to the students, and it has been always a pleasure for me to talk to them. Thank you. Thank you very much.
Thank you, sir, for these insightful, for this very insightful session on this topic. And